live. This is Law Call.
Hey, welcome to Law Call. I'm attorney Chris Young with the law firm of Perry & Young. Tonight it's Ask Us Anything. So if you got a question about a legal matter and you try to find an answer for you, give us a call. We'll take your call live, 850-392-1544, or you can always email us at lawcall@wmbb.com. I'm joined with one of my close personal friends who happens to just be one of my law partners, also Ted Howell tonight.
How y'all doing?
They're doing good.
They're doing well.
They're doing well.
Not going to answer.
They're doing well.
Yeah.
So it's Ask Us Anything.
Not literally anything.
Well,
try to make it about the law.
Try to make it legal, and we'll take your questions live and hopefully get you an answer, get you shoot you, and get you directed in the right direction. So, Ted, we're going to jump right into it. I do believe we have an email from David, and David, if I had my brights on and it blinded another driver, they hit a deer, would I be liable for their injuries and car damage?
David, that's a very interesting question. We have a lot of deer out on the road. You got to always be safe anytime you're driving, especially when you get into the fall, winter time frames. Potentially, but I think it's going to be very difficult in a case like this because and we've had a lot of people call us where they've been in accidents, single car accidents with a deer, and they want to know what their rights are and their responsibilities are. As a general rule, you cannot sue deer. They don't carry very good coverage.
That might be a good business angle for some insurance companies to insure these deer.
It could be, but it's not going to work out very well. The only way that this potentially could have some angle on liability, if you have your brights on and it's a time where you're passing a car and you should have dimmed them down, that could have been the failure to use reasonable care under the circumstances. But then you're going to also have to have causation that somehow that distracted the driver or prevented them from seeing them, and then ultimately that led to that collision with the deer. But there's a lot of other things in play there, especially when you're dealing with a deer that comes out. So I think the answer is possibly, but very, very unlikely. And that's why it's also important to carry comprehensive coverage on your vehicles so that when you do have those unfortunate situations where you run into a deer, you have coverage on your own policy to help pay for that property damage, because otherwise you're going to be looking at a very, very large bill.
Well, under our current scheme right now, also, Ted, you've got personal injury protection as well.
Yes.
And so in the event
that's going to apply either way.
Right. So if you're the person who got blinded and hit a deer and run into the ditch, your own policy is going to kick in, because currently in the state of Florida, we are a no-fault state.
Right.
And you are afforded personal injury protection benefits under your current policy, up to $10,000. Typically speaking, they pay 80-20.
Yes, 80%, and then basically like a 20% copay.
They can pay some lost wages. And Ted, a lot of times we get asked the question, why is my insurance company paying? And even though we say we live in a no-fault state, people they get very confused. They either think that they have no claim whatsoever against the other person because we're a no-fault state, or they're confused as to why their insurance is paying and stopping at $10,000. So, there's been a few clients that have come in probably the last couple months that have raised this issue and said, I didn't know I had a claim because we're a no-fault state.
Now, I've actually had a couple people tell me that the law enforcement on the scene told them that they were not going to write a ticket and that they were not going to do anything else because we're a no-fault state, which is, as I tell people all the time, yes, we're a no-fault state, but that does not mean what it sounds like it means. All that the no-fault aspect of the law means is that we're all required to carry PIP, personal injury protection, which is the benefits that Chris just discussed, that allows you to get coverage up to $10,000, whether it be for your medical expenses or potentially for lost wages. It can cover that as well. And that's something that kicks in immediately if there's an accident in an automobile. But that does not mean that you do not have a claim against the person that caused the accident. And that also doesn't mean that law enforcement cannot cite someone if they violated, failed to yield the right of way, ran a red light, what have you. If they violated the rules of the road under Florida statutes, they can be cited even though we're a no-fault state.
So Ted, we have rules of the road violations, and then we have citationable rules of the road violations. And so just understand, just because an officer does not issue a ticket, some type of traffic citation, does not mean that you don't have a claim. Does not mean that you can't pursue your claim. But even though we are a no-fault state, that no-fault only deals with your medical attention up to $10,000 originally.
Right, because when you have an accident, you do have a claim against the person that caused the accident, but that liability policy of that other individual will not pay as you go.
Right.
So, for example, you need to have treatment when you've been in an accident, because the most important thing is to try to get back to the position you were before that accident. And to do that, you got to get medical attention. And to do that medical attention, it's got to get paid for.
Right.
And so what the PIP does is it helps start that and make sure that that gets paid just like health insurance. And when you're in an auto accident, PIP or no-fault benefits are your primary form of insurance until they exhaust. But it's also important and critical to make sure you give all of your medical providers any health insurance you have, so they either bill that as secondary or they have that on file if and when your PIP exhausts. And I have a number of people, and even some medical providers, that will try to get folks to say, I don't want to have my health insurance bill because this was an auto accident.
Right.
Or they'll say, I want to put this on the other person's policy and you need to bill them. That's not the way a liability policy works. It will only resolve once and only one time at the end of the case. And you need to make sure you know what your injuries are and the extent of them before you resolve that claim.
But Ted, along that same vein, a lot of individuals, they're like, well, why do I have to file it on my own Blue Cross Blue Shield
Right.
policy or United Health or whatever they have, or TRICARE? And that's to their benefit.
Exactly.
No matter if you got sick for something that's just of nobody's fault, or if you got involved in an auto accident, your health care provider is going to provide you health care insurance coverage,
Right.
assuming that you have it, right?
And there's huge benefits there.
Right. Now, we can jump into that too, because what will happen is they will pay for your bills as you incur them and as they stack up against you and you're not sent to a credit bureau. Mm-hmm. And then at the end of your case, you have what this fancy word of called subrogation, and they have a lien against your case, and they can subrogate it against any funds that you have. Now, you're like, well, man, how do I do all that? And you know, but there's been a lot of individuals where their insurance company has paid. They came to us because they got frustrated with trying to do it by themselves, and they would have made some very costly decisions had they you settled their case, because there's a big lien out there
Right.
with their health insurance company.
Right, because the most important thing at the end of the day is what you net at the end of the day. And so you want to get as much money as you can from the at-fault party to be fully compensated. At the same time, you want to keep your medical expenses down as low as possible so that you
Right.
can be compensated for those non-economic damages, the pain and suffering, the loss of enjoyment of life, all the things that goes along with recovering from an automobile accident. That health insurance has contractual adjusted rates that they pay. That's not the sticker price or the retail price that
Right.
you would get if you just went in without health insurance. So it's important to get those negotiated rates that the big insurance companies have to press down what you have to pay for those medical expenses. Now, if and when you settle the case, they do have what's called a right of subrogation, which means they get reimbursed out of the settlement proceeds. But at the end of the day, that's better for you, because what they paid is less than what you would have had to have paid if you tried to pay for it on your own without going through the contractual adjustments. Because health insurance, as anybody has seen on their explanation of benefits or explanations of review that they get with their payments, there's a large percentage of a bill that gets written off that the insurance company doesn't pay, that you don't pay. You do have your copay or deductible, but the insurance company will pay an agreed upon rate, and a large portion of the bill will get written off. Now, they don't obviously have a right of subrogation or a right to be reimbursed for what got written off. Right. It's just for what they actually paid. So it's important to get those bills down as low as possible.
That is a lot to digest.
Yes, it is.
Now, phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. We have another caller on the line, Leslie from Alabama, with a tree issue. Go ahead, Leslie, with your question.
Shut up, Carl. You play too much. Hush. Hush.
Leslie, can you hear us?
Yes, I hear you.
Okay, go ahead with your question, please.
My question is if you're driving down the road and a tree falls, who is liable for the vehicle damage and stuff like that if you don't have full coverage?
Okay.
We've actually had cases similar like this, Leslie. The biggest issue there is, once again, if a tree just falls and it's not anybody's fault, that's considered more or less an act of God, and there would not be any liability. However, if there were conditions where the owner of the property where the tree is located knew or should have known that there was an issue with that tree, i.e. it's been rotting, it's got branches that are falling off of it, and people have put them on notice that this is a condition that is dangerous and needs to be rectified. In those situations, you can have liability on the owner of the property where that tree is located. We've had a situation where a landowner has been put on notice of an issue, actually had someone sent out there to actually try to take out the tree. They didn't do it properly, they didn't do it timely, and that tree fell over and hit somebody. And that's a situation where there was liability on that landowner. We have others where there's been trees on properties and the tree was not properly maintained by the landowner. It's fallen over and actually hit individuals. And those are situations where the landowner knew or should have known that they had a problem on their property and failed to act. It's a negligence standard. They had to have failed to use reasonable care on the circumstances. If you know you've got a problem and you put your head in the sand and don't deal with it, you're going to have liability.
Because you're going to be judged as a reasonable person.
Right. It's not strict liability. It's not just because, just like with a slip and fall on a business premises, they're not liable just because you fail. They had to fail to use reasonable care under the circumstances. And so there has to have been some reason, or if they have actual knowledge, or if under the circumstances they should have known. For example, if the tree had been in a serious state of decay for a long period of time and they're just not properly maintaining their property and checking up and looking at it.
And a lot of times cities, municipalities will give citations for failure to maintain, creating a hazard.
Right. And that's why it's important as a property owner, if there's a neighbor that you have and you see that they have a tree, you need to reach out to them and put them on anything you can put in writing to them. I mean, it's a neighbor. It's best to go talk to them and have something, face to face, and let them know, hey, it's something you need to deal with. But if it stays and they don't deal with it, put it in writing so that you've got that evidence, that you put them on notice that it's a situation, so that if and when it does cause some damage to your property, you have that
as proof,
as an Exhibit A when you need to file a claim against them.
Let's hope it doesn't get to that, Leslie. I hope that we could help you out with your question. Phone lines are still open, 850-392-1544. You can always email us at lawcall@wmbb.com. We're going to take our first break of the evening. We'll be back in just a moment. And welcome back to Law Call. Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. We have a special show tonight. It's called Ask Us Anything. Ted, you've already alluded to this. Ask us anything legally, hopefully.
I can answer most things, though. At least I tell everybody that.
Yeah, that's what you tell your wife. But anyways, we do have another email question that came in during the break, and we'll just go ahead and jump right on that as well. And it's from Tom, I believe it is. We got that question to pop up here. There we go. I was bit by my neighbor's mastiff while mowing my lawn. It's so large it just leaned over my fence and bit me on the arm. I plan on getting it treated tomorrow. How can I get them to pay for my medical bills? They think it's no big deal and I should just have to tell them when I mow the lawn so they can put their dog in. Well, Ted,
Tom, I can tell you that's not how it works.
Yeah, and you don't get a first bite for free in Florida.
No, Florida has a statute that deals with these situations directly, and as long as you're in a place that you have a legal right to be in, which you do in your backyard, they have, we talked earlier about negligence and having to show liability and failure to use reasonable care. Well, in this situation, it's what's called strict liability. And so the dog owner is going to have liability in this particular scenario. I also recommend that you call animal control. It's important to always do that and report when situations like this happen so that you have it properly documented and so that they take care of that dog. You want to make sure it's checked. You want to make sure you're checked so that you don't have any conditions like rabies or other things that may be a problem. But there is the bigger issue that comes down on these dog bite cases a lot of times is there coverage and or are there assets that the other individual has that can compensate you for your loss. Very frequently people will have exclusions on their homeowners policies that will exclude dogs, or if they do have coverage, they have a sub-limit that is much lower, like as low as maybe $25,000 for these types of actions. So, and if somebody has a Mastiff, they may or may not have told their insurance agent they have a dog.
I can tell you as a former owner of a French Mastiff, they are very large dogs.
Yes, and insurance companies don't like those kinds of dogs.
Now, I never had an issue with Bo, but let me tell you, when they grab a hold of something, they've got something.
And they don't let go. So it's, yes, you absolutely have a claim. Yes, it should be pursued. Please make sure and reach out to us or someone like us and make sure that that is properly taken care of, because they can be tricky to navigate.
Now Ted, let's just go down that rabbit trail for just a second. Dog bite cases are very serious.
Yes.
And courts look at those cases very seriously, and insurance companies hold those in high regard. And they're
because of the reason we talked about, strict liability.
Right, and so, our firm has been successful in recovering hundreds of thousands of dollars.
In the right case.
In the right case, on a dog bite case. And, you just can't dismiss that and say, oh, well, my neighbor's gonna push me around and tell me that, just let them know, get permission to cut my own yard so they can put their dog away. It doesn't work that way. And, actually, a public service announcement, if you've got an animal, a pet, please make sure you understand that if they bite another individual and cause harm to that person, these pit bulls, those are substantial injuries. Pit bulls and Rottweilers seem to be the most prevalent ones, and they cause very serious injuries and permanent scarring. And so please, just understand, when you own one of those type of animals, you are strictly liable for anything that animal does.
Right. And another one, and it's not just biting. I mean, especially when you have a bigger dog, and there's folks that will just let these dogs run wild in their neighborhoods without a leash on. And if that dog comes up and runs up on someone and gets excited and knocks them over and causes them to have an injury, they're liable for that too as well.
Right.
So it's important as a homeowner or a dog owner to make sure that you're properly maintaining your animal, keeping it leashed when you're out, making sure you have it properly fenced and away from folks, so that you're just being protectful and it's just respectful as well.
Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com if you don't want to go on the air. We do have Thelma from Elba, Alabama on the phone, and Ted, I think you did such a wonderful job answering a tree issue. Thelma has a question about a tree as well. Go ahead, Thelma.
Okay.
I have trees it's tall in the air, and they grow over a circle in the air on my neighbor's side, and their trees grow over on my side. So I'm the one got to have it paid to cut down, or do I inquire to my homeowner insurance?
Okay. So, Ted, basically, we've got overhanging trees on both sides of properties, and who's liable and who's responsible. And I think you'd have to go to see where that tree's rooted at.
Right. That's part of the issue. Now, your homeowner's insurance is not going to cut your tree down for you.
Right.
So that's so the homeowners is not going to be able to help with that, Thelma. It's best in a situation like that to get with your neighbor and coordinate doing it together, because just like they say, good fences make good neighbors. Conversations and communications make good neighbors as well. And so it sounds like you have a situation where maybe you have trees that are overgrowing on both sides. And as a general rule, as the person that has the tree rooted, you need to make sure and take care of that. But you do have rights to make sure and keep the airspace above your property clear as well. But the best tact in a situation like this, especially when you have it going both ways, is to get together and coordinate with your neighbor and have somebody come out and take care of that all at once.
Because you can share expenses, because it's going to cost the same to get that person to come out one time, or it's going to be double to have them come out twice. So,
and it's just easier if you can coordinate, because sometimes you have to go on other people's property to get it done correctly.
Make friends with your neighbor, man.
Yes.
Phone lines are still open, 850-392-1544, and you can always email us at lawcall@wmbb.com, and actually have another email question that just came through. So I've been contacted by a war occupational child via DNA search that I was not aware of, and that is a citizen of another country that I was never in. Can the person which I acknowledge as my offspring be a claimant to my estate?
Wow. That's a very interesting question.
It may be a little fishing there.
Yeah, I'm not, we need more details on that, but the short answer is, and depending on your state, if it's somebody that, has been determined to be your biological child, there is the chance that they could, if you do not have a will and do not name them in there, if it's, for example, that's called intestate, that they would take. However, you as the master of your own domain get to decide who takes, as long as you draft a will and be very, very specific. And I'd want to make sure you consulted with a probate attorney on this to make sure you are identifying that you may be aware of this situation and you are intentionally making the decision to not leave anything to that child. You want to make sure, because different states have different rules on that, and you want to make sure you're properly protecting yourself. So it is very, very important in a situation like this, especially if you think there is some merit, or even if you don't think there's validity to it, that you are documenting it properly in your estate documents.
Right. And be very, very careful, because if you've never been in that country before and that person is contacting you saying that you were, you may be getting scammed. So the best way to handle that is just prepare a will, be very specific, talk to a probate attorney who does that day in and day out, and they can give you the guidelines, and make sure that your estate is protected for your rightful heirs, or whoever you choose to take from your estate, because your will is basically a roadmap for the court to honor your wishes.
Because your children don't even have a right to take. If you want to take and give it all to the church, or give it all to...
You want to give yours
to
them?
Yeah, I might. You never know.
We have another call on the line. We'll get this real quickly before we go into our last break. Susan from Bay County, go ahead with your question, Susan.
Yes. I have relocated from Georgia several years ago and had my wills updated in Florida, but did not have my living will or my powers of attorney documents updated. And so my question is, those were drawn up by a Georgia lawyer, so are they still valid in the state of Florida?
Great question, Susan.
Susan, typically if they were valid when drafted, they're still going to be valid, but the issue we have is there's been a lot of changes in the law, and there's been a lot of updates. So to be safe versus being sorry, and you also have the issue of people down here being used to seeing things drafted a certain way consistent with Florida law. So I would be very, very, because there's two different, anytime you're dealing with powers of attorney, even if they're valid, if the person that you're trying to give it to doesn't accept it and doesn't want to take it at the time, it can be a roadblock. I see
or
that.
Or it may be a good time to revisit that too.
Well, and I can see it, even if they're valid, you can have roadblocks and people don't want to accept it and make you jump through additional hoops. So, Susan, I would highly, highly encourage you, because that's something that can be changed and updated very, very easily. So I would seriously have that, consider having that done.
All right. We're going to take our last break of the evening. Phone lines are still open, 850-392-1544. You can always email us at lawcall@wmbb.com. We'll be back in just a moment to wrap things up. Hey, and welcome back to Law Call. We're wrapping things up now. We tried to jam in every caller and question and email that we could get into when we
kind of started flying there fast at the end.
Between trees and all kind of stuff. But anyways, Ted, we've got about a minute left in the show. You and I are probably going to be busy next weekend.
It won't be us.
It won't be us.
We may be holding a big fish up. Hopefully,
let's hope we're holding up a big fish in the Billfish tournament.
Or we can't hold it up. It's too big.
You could. But anyways, join, come out and support the local Bay Point Billfish Invitational. Those guys do a great job putting it on. From George Roberts,
Randy Hauser
and
on Wednesday,
John Warren and Scott and Todd Neves. They all do a great job out there. And Jay Quave. Sorry. But anyways, let's jump into these shout outs and.
I just had a few. I had Brooke, my cousin Brooke, up in Mariana watching tonight, and I'm gonna let you go.
Oh my goodness! I've got Ashley, my mom, Trey Smith, Judy Smith, Christian and Maddie Bushon, my niece and nephew, Miss Pam Myers, the Gary Star.
Oh yeah, you stole that one from
I
me.
did. I'm sorry.
Sorry, Gary. Wanted to do it.
Omar's watching. Thank you, buddy.
Yeah.
Glad for all the encouragement. Paula Frederick and Rick from the Marlin is watching. So.
Wow.
I'm going to give a shout out to Judd and Vivian and Heather and Randy and Jan, all the people that Ted forgets in his life. But anyways, if you don't have any plans over the weekend, go out to the Bay Point Billfish. It's a great time out there, and support local businesses putting on a great event. Same time, same place next weekend. Thank you for tuning in tonight. And if you've got questions during the week, you can always email us at lawcall@wndd.com. And have a great week.